Okay, welcome to this morning's session of the Kansas Court of Appeals. I'm Chief Judge Karen Arnoldberger. I'll be presiding over this hearing today. With me is Judge Stephen Hill, the oldest, or the one, not the oldest, the longest serving.
Thank you.
Longest serving legally trained judge in the state of Kansas. And next, the other judge on this panel today is Judge Patrick McEnany, who appears with us today as a senior judge assisting our court. You all are familiar with the rules of the Court of Appeals. Just know that we've read the facts of your case. We are familiar with them, and you do have only 15 minutes to argue, so you really don't need to spend time outlining all the facts, except to the extent that it bears on the particular argument you're making today. So with that, I will ask the parties enter their appearance, please. First for the appellant.
Megan Lewis for the plaintiff appellant.
Okay, thank you.
May it please the court, Kelly Tressel appearing on behalf of the appellee.
Okay, Ms. Lewis, did you wish to reserve any time for rebuttal?
Yes, Your Honor, 3 minutes, please.
Okay, thank you. You will receive that. You may begin.
Good morning, Your Honors. May it please the court. This case presents an arbitrary and capricious decision by the district court, which exceeded the proper bounds of its discretion in each of its 3 rulings entered on January 16, 2020. The district court's decisions stem from the plaintiff's effort to seek a short continuance of the trial proceeding, no more than 30 days, to confirm the proper party to substitute and identify and prepare an appropriate corporate witness for trial after the original plaintiff's assets, including its interest in the instant case, was sold to a new entity after a separate foreclosure action. The district court committed reversible error when it dismissed plaintiff's case with prejudice for failure to prosecute after denying plaintiff's motion for voluntary dismissal without prejudice and after denying plaintiff's motion for continuance. The district court's decision was neither fair nor equitable under the circumstances. The first issue I plan to address is the district court's dismissal with prejudice. The district court dismissed plaintiff's action with prejudice under Section 241B for failure to prosecute. It was improper when this matter was pursued diligently and had a reasonable and necessary excuse for delaying trial by a mere 30 days.
Okay, let's stop right there for a minute. You said when this case was pursued diligently. Looking at the facts of this case, I find it hard to believe that anything was pursued diligently in this case. This was a pretty standard violation of a lease agreement. It did not appear to present any kind of complicated issues at all. Yes, yet it was twice put on the dismissal list for failure to prosecute, with this idea of a last-minute continuance being kind of the status quo for the plaintiff in this case. And it's the plaintiff's case to proceed. So how do you reach the conclusion that this was diligently pursued?
Yes, Your Honor. Within the first 6 months of the filing of this case, the parties exchanged written discovery and both propounded by the plaintiff as well as by the defendant. And I will also note that there was efforts to depose, and eventually there were depositions of necessary witnesses. And I'll finally will note some of the continuances for this matter was attributable to settlement negotiations. Multiple entries in the court's record note that continuances were necessary to allow these negotiations to continue and also to accommodate the schedules of both counsel.
Okay.
Let me interject a question here. The plaintiff in this action, at the time it reached for trial, was the receiver, not the underlying owner of the property, who would, and in fact, the receiver, the property had already been sold at foreclosure, so the receiver, I take it, had no authority at that point. Is that correct?
For the timing, yes, the timing was within about a year of this action being filed. The original plaintiff became subject to a lender action brought by Wells Fargo in a separate matter, and resulting the appointment of the receiver, who is the named plaintiff herein. And eventually that matter proceeded for about 6 months, including an eventual foreclosure of the original plaintiff's assets, including leasehold interests in the original.
Well, I understand all that. I'm going to cut you short just so I understand. At the final hearing, were you attorney for the receiver at that hearing?
I was not physically present. No, I have just been appellate counsel. But to answer your question,
let me get to that hearing. The plaintiff's lawyer at that hearing, who was the receiver, the lawyer said, "I don't have a corporate representative for the new entity. I'm not sure who's the correct entity. I've been in constant contact with the receiver." That's the lawyer talking about his client, the receiver. The receiver is managing to transfer the assets. And he goes on, and then the attorney says, "I've been trying to get somebody to step forward." And I guess my question is it clear that the receiver was either the plaintiff's lawyer or the receiver were in contact with both Wells Fargo and the new owner, or just Wells Fargo?
It is my understanding just in contact with Wells Fargo. There was a lack of clarity on the assets that were transferred and whether Wells Fargo or the new LLC, which has a very long name, was the correct entity to pursue this action at trial.
So if the receiver is only in contact with Wells Fargo, and Wells Fargo is really the proper party. That the new buyer is the proper party in interest, who's the owner of the claim, essentially. Then the court's action is basically punishing the real owner of the claim for conduct of the receiver and of the prior owner, basically Wells Fargo, after the foreclosure action. Is that correct?
Your Honor, I would agree with that.
That's the problem I'm having, and I'm asking you as probably a heads up to opposing counsel, but to address that when we get to it.
Yes, Your Honor, and a significant issue here is the district court's failure to assess the prejudice to the named plaintiff, the receiver, or the new owner whatsoever in its decision making.
Isn't that speculative? You can't tell us now what the new owner's position is, can you?
Well, Your Honor, the leasehold interest in this case, including the back rent owed and the acceleration of rent, is quite significant. We're talking.
But who do you represent in this case? Do you represent the receiver?
Correct. That is the named plaintiff who I represent. And should this matter be remanded to the district court, we will move for a proper substitution of party with the new entity, which is the LLC entity.
So you cannot tell us what the new entity with the long name, what their position is in all of this.
Your Honor, they are prejudiced because this is a viable claim against a.
No, I'm not asking about that. I'm asking what is their position. You can't tell us because you don't represent them.
I do represent them. They're not a named party currently, but will be upon substitution. And the Kansas statute, section 225, allows for a matter to proceed in the original name's party, in the original party's name, and can allow for a subsequent substitution. There's no time limit.
One more question. Didn't you, the receiver, know, at least I garnered from the record, that you knew 5 weeks before trial that there were new owners, but you waited until the eve of trial to seek a continuance?
That is slightly incorrect. The sale was, I believe, in December 10 of 2020. I'm sorry, of 2019, and trial counsel for the receiver was not aware until of the sale until December 20th, and that was advised to the court at the trial proceeding. Unfortunately,
What was
due to
the day of the trial?
January 16. And unfortunately, between December 20th and January 16 are two significant holidays where it's very difficult to get a hold of opposing counsel or different corporate entity representatives to confirm who would be available and the proper party. And I will also add that that opposing counsel was aware of the issue of a potential motion for continuance a week prior to the trial proceeding. Moving on, to be clear, that the Supreme Court of Kansas recognizes that a dismissal under Section 241 is a drastic action. It is to be exercised with the utmost care and reserved in only the most extreme circumstances and only where a lesser sanction would not serve the ends of justice. Such extreme circumstances are not present here. And it's important to note that the court did not engage in any oral argument or weighing of factors pertinent to Section 241. All oral argument at the January 16 trial proceeding was in relationship to the motion for continuance. Only after the motion for continuance was denied did the defendants move for a dismissal with prejudice orally on the motion. Prior written objection to the continuance did not seek a dismissal with prejudice, and the district court summarily granted the dismissal with prejudice after denying the motion for continuance, after denying plaintiff's motion for voluntary dismissal without prejudice, and without engaging any further findings of fact, conclusions of law, or other weighing of factors. Again, the transcript only reflects discussion regarding the motion for continuance. And I will briefly go into the second issue, which is the district court's denial of the plaintiff's motion to dismiss without prejudice under Section 241A2. Kansas Supreme Court makes it clear that unless the defendant will suffer some plain legal prejudice other than the prospect of a second suit, the dismissal should be allowed. And the district court made no findings whatsoever regarding actual legal prejudice suffered by the defendants, and made no findings whatsoever regarding any inequities or unfairness to befall the plaintiff.
Wasn't there discussion from the defendant that they brought in witnesses from out of town for trial and had gone to some expense to be ready for trial the next day?
Correct, and that was only in the context of denying the motion for continuance.
Okay, all right.
Okay, and I'll reserve the rest of my time for rebuttal.
Okay, perfect timing. Thank you. Okay, Ms. Kelly, or excuse me, Ms. Trussell.
Thank you. First, I want to clarify a couple of points just on the timeline with what led up to the January trial date. December 10th is when the foreclosure was entered by the district court. And that was actually done by the same judge that presided over this case. He had both cases. But that was entered actually on December 10, and it was December 20th that the plaintiff's counsel then began trying to communicate with the plaintiff client to determine who would be the corporate representative for trial. And so there was a 10-day delay from the entry by the court until there was actual communication attempted on behalf of the plaintiff's counsel. But then that continued. This attempt to find out the answer to this question of who would show up for trial happened between December 20th, apparently all the way up to the day of trial. And so I did want to clarify that before I started into my argument. The district court, we believe, fairly and properly entered this 241B dismissal. The record demonstrates full support for the dismissal by the trial court. The plaintiff had full notice of this possibility of dismissal. In Shawnee County District Court, when there is a lag in a especially a limited actions case, there's a notice that goes out to the parties. And in this case, there was twice a dismissal notice under 241B explaining to the parties there's the lack of prosecution issue here and it needs to be tried within 6 months. Now, this case lingered for 20. There was good reason for some of that lingering. We don't take issue with the fact that it was just the length of time. The bankruptcy issue alone was a reason to delay some of this. And the defendants acted rather reasonably with that. We gave long continuances to allow for that proceeding to occur. And the other issue with this was discovery. We waited for a year. We tried for a year to do one deposition. And that was the only deposition that we needed for discovery. And after a year's time of asking and being promised that it would happen, we finally gave up and just said, let's set it for trial. And so, this what happened in January 2020 was basically a summation of the 20 months. The defendants' side, it was us, it was the defendants who was actually pushing this case. Trying to get it to a resolution. It was a serious matter. We took it very seriously. John Parker was personally looking at a judgment up to almost $850,000. And so there was a diligence in trying to get this resolved for him personally because he wanted it resolved. But then also, it was 2 years. The trial date in January 2020 was 2 years from the time that Pizza Pub had actually closed its doors. They couldn't wrap up the business. They couldn't, finalize the entity with this matter pending. And so there was a push from the defendants to try to get this, resolved. And then the communication that we gave plaintiff's counsel once the foreclosure went through was, we're not delaying anymore. We need a trial date. And then leading that week up to the trial, suddenly there's now an issue with plaintiff's counsel contacting us and letting us know that she's not sure if she has a corporate representative for trial. I diligently talked to plaintiff's counsel that entire week leading up to trial. Phone calls, emails, texts. All of it was in communication, trying to determine, are you going to file a motion to continue or not? My client, John Parker, lives in Washington State. He was going to get on a plane to travel here. Almost all of our witnesses were voluntary witnesses, but they were out of town. They were going to travel. They were going to make work arrangements. And so we stayed in communication. I even communicated when his plane was leaving, what time his plane would leave. And still no motion to continue was filed until hours after takeoff. And so this was not just a spontaneous, we showed up for trial and suddenly the plaintiff wasn't ready. There was a lot of history here, and most of that is completely on the record taken up that day at hearing. But I also noted in my written objection to the motion to continue 9 issues, and all 9 of those issues not only go to the 3 factors that the court needed to consider in whether a dismissal was appropriate, but also whether this motion to continue was appropriate.
Counsel, let me interrupt you if I can, because my big concern in this is the dismissal with prejudice. That's the drastic punishment that we have for dilatory tactics. You not only lose your case, but you lose your ability to ever file it again. Why is that appropriate in this case? Why is it reasonable in your view?
In my view, Your Honor, it was really the only solution to the January 2020 no-show of the plaintiff. And I'll break that down as to why. In the first place, for the same reasons that we argued that the motion to dismiss with prejudice was appropriate are the same reasons that we say that the motion to continue should not have been granted. There was a lot of harm that had occurred to my clients that was financial, and that could have been dealt with. The attorney's costs, the prep, the flight, even, lost time for my witnesses, all of those things could have been financially taken care of by sanctioning the plaintiff or something like that, some other sort of remedy in granting a continuance. But what you could not cure was the prejudice and unfairness of what was happening with the delay. The defendants had lingered for 20 months waiting for a resolution to this case. We had tried over and over again to get this case to trial. And then so you can't fix that harm. The delay is still the delay. And
well, counsel, excuse me just a minute. This is kind of a different approach than I understand was taken at trial, because as I read the transcript of the hearings, were you trial counsel at that hearing? Okay.
I was.
You said my client's got a considerable expense to defend this case, flew in for depositions, blah, blah, blah. The travel was, he came from the state of Washington. Your other witnesses came from Lawrence and Kansas City.
Correct.
Not overwhelming distances, view of the fact that those on the court routinely travel in that distance every day. But be that as it may, went on to say, we're ready to go. It's been 2 years. If the case is continued, we're going to have to ask for costs and expenses. Now, the court never did. So you were acknowledging that a delay there could be compensation that would cover that. And the court never considered that, did it?
The court never considered what compensation?
The court never considered it, as Judge Hill describes, and as I've characterized in the past as a district court judge confronted with these things. This kind of a motion is asking for basically civil capital punishment. And in that situation, it's a last resort, and only resorted to when there's not some other form of relief. And here you're acknowledging that if you pay our expenses, maybe we can get this thing continued, but it was only going to be continued for 30 days.
That was the request, was to continue it for 30 days. Now, I don't know when it would have been continued to, because we never got that far. I mean, I don't know with the court's calendar and things like that, if it would have been 30 days or would it have been 3 months, we don't know. But they were requesting 30 days. And no, we didn't get that far. I did say for the record purpose that, if you're going to continue this, we would want to stop and ask for costs and repair that harm.
Well,
but we
counsel,
didn't.
it appears to me in the history of this case and the lack of diligence on the part of the plaintiff, that could have been another year that this case would have been delayed, because they're always looking for somebody else to be in charge, and they didn't know what was going on. It looked like to me.
And that is true. That was the theme that happened throughout this litigation was, it's unusual to have, at least in my experience, to have the defendants being the ones trying to drive the bus, so to speak, to get to trial. But that was what we did in this case. It was a constant push by the defendants to try to get this case moving.
But the person that's injured in all of this, if there is an injury sustained, is the real party in interest for the plaintiff, which in this case would have been this Wanamaker Road LLC, the buyer of the property. And they bought the property on December 10, before this trial in, what was this, January or February? January 16th. So the receiver up to that point, who is the plaintiff, and is the real party in interest because he's been appointed the receiver for the property for the then owner, which was the mortgage holder, Wells Fargo. he was acting on behalf of Wells Fargo, and you're not attributing all these delays to Wanamaker Road LLC, which is really the real party in interest when this matter comes up to trial, are you?
I don't know. The issue.
It's a punishment on the person who owns the property, who would have the claim, and that claim didn't own the property until 6 weeks before the trial, and all the delays occurred before that.
That is true, and I don't know. I honestly don't know a whole lot of the relationships on the plaintiff side. I don't particularly know who the proper plaintiff even today is. But that was really
Wells Fargo. Well, the proper party. Well, I guess let's see. They bought the property. Wells Fargo held it before, and before the foreclosure, it was held by whoever owned the mall. It certainly wasn't Wanamaker Road, was it?
There's been no substitution of parties. So as far as I'm concerned, isn't it still the receiver as the party in interest in this particular hearing? Because there's been no entry of appearance by the new owner.
That's correct. There was the last substitution of party was for the receiver. And it's been left there since. And I don't know that I don't know that it's appropriate when the plaintiff had plenty of notice prior to trial that this issue had occurred, that the sale had occurred. I don't know that it's an appropriate situation then to just tell the defendant, well, you're going to have to wait longer. And they have a right to have a day in the court too.
Well, Ms. Lewis tells us that it's her understanding that the receiver contacted Wells Fargo to find out who should be substituted, rather than contacting the new owner, who may not even have been aware that this case was pending. So, do you have any evidence to the contrary that in fact the true real party in interest actually knew about this case before this hearing took place?
I have no evidence to that. That was never, I never even got to depose anybody from the plaintiff. So I honestly do not know what is that side of the fence look like. I don't know. But it wasn't the defendant's responsibility. It was the plaintiff's responsibility to prosecute their case. And, we were so patient through so many issues in this case. And it got to the point where it was becoming this cumulative harm to my clients to continue to do that. So we made it clear. We put them on notice. We're going to object to any more delays. And we did that in lots of time ahead. And they could have filed their motion to continue a lot sooner than less than 24 hours to trial.
My last question for you, and I promise it's my last one, is what's the harm in granting the plaintiff's own motion to dismiss? How would that harm your client? I mean, granted, it's not a dismissal with prejudice, but still, it's a dismissal. There's no guarantee this lawsuit would have been refiled.
You're right, Your Honor. There is no guarantee that the lawsuit would be refiled, but that is the actual harm. If the lawsuit would have been refiled, we would have started over again. And that actually would have been more harmful than continuing to delay the trial that we were trying to get to. We would have started clean over again. And
we have some cases that say that the threat of refiling is not a kind of prejudice that would justify a dismissal with prejudice.
That is true. What I'm answering what I'm trying to answer is, what is the harm in doing the dismissal without prejudice? And what I'm saying is, as an alternative to dismissal without prejudice, I would have favored the continuance before I would have gotten on board with a dismissal without prejudice, just because of the implications to my client down the road. It's better off for them to just continue the trial we have. instead of gambling over whether we were going to restart all over again. And so that's, at the end of the day with this, the standard of review in this case is whether the district court acted without reason, whether, and that's, he did not act arbitrary. He had support. He gave ample opportunity to the plaintiff's counsel to articulate reasons as to why we should delay. And, at the end of all of this, plaintiff's counsel said, this just may not be the most important thing to my client right now. And I think that is actually a great summary for how the whole 20 months went in this case. And I'm not judging the plaintiff for it as far as whether it was important to them or not, but it was very important to the defendants in this case. And they had rights. They had rights to litigate this case. And, we cannot get lost in the fact that the plaintiff wasn't prepared that day. The defendant was prepared that day. Oh, but what about the plaintiff's case? Well, the plaintiff had the responsibility to prosecute their case, and they didn't. And they didn't for 20 months. This wasn't a new occurrence on January 16th. And so the standard of review, coupled with what are the rights of a defendant, I think really does need to be, given some time and thought and in looking at case law in order to make a decision in this case. So for those reasons, we would ask that it would be affirmed.
Thank you very much. We are ready for your rebuttal, Ms. Lewis, but before you start that, I have a question related to this, and Ms. Trussell mentioned it. During the hearing, the person representing the receiver in this case did make statements like, I'm not really sure this is that big of a deal to my client, but to the new purchaser. We're having a really hard time getting a hold of them. They don't seem to think this is a big deal. And you would think somebody purchasing a property would, with due diligence, realize they have an upcoming trial with $800,000+ at stake. But this plaintiff that you wanted to substitute, we have to assume knew that was pending when they purchased, yet weren't being responsive, according to the person that represented your client at the hearing. I think that the term was this was really small potatoes for them. How do you respond to that? I mean, Ms. Lewis has indicated we don't know if it would have been heard a month from now or a year from then, because at least all indications were your client didn't take it or your client now, the purchaser of the property, just was not taking this seriously at all.
I think at the hearing, all of the language that was raised by the court as well as plaintiff's counsel was couched in speculation, because plaintiff's counsel was attempting to contact the right person and confirm who that person was. And unfortunately, with the holidays and with multiple entities involved and the timing, it is nothing but speculation as to whether it was perceived as being small potatoes or not. But here we are today pursuing the appeal, and it is not small potatoes. The record clearly shows that the interests are quite significant, and the resulting receivership was also significant. The fact that a receiver was appointed in the first place, there were a lot of assets at stake, and to track whose assets went where, it's quite an undertaking. And like I said, the timing was.
Well, I'm assuming when a foreclosure takes place, it wasn't a great shock to the receiver as to who bought at foreclosure. That was probably known ahead of time as well, wasn't it?
I think we needed clarification on which assets went with which purchasers. The subject of the foreclosure was not just the leasehold interests into the mall. There was other property of the original plaintiff, Westridge Mall LLC, that was subject to foreclosure.
Okay, thank you. Go ahead, you have a couple minutes.
Sure. Yes, I want to make clear that as raised by Judge McEnany earlier, this is truly a drastic remedy dismissal with prejudice when no other lesser sanction would serve the ends of justice. This is not a situation of extreme circumstances. There was a reasonable excuse. There was a separate proceeding for many, many months that clouded this action. This is not a case of seeking an indefinite continuance or an indefinite stay or a limitation on the ability of the defendants to litigate the case on the merits. It really was just seeking 30 days of a continuance to ensure the right party and interest could pursue a judgment that was not going to waste judicial resources and be faced with collateral attack later because it was the wrong party and interest. The district court did not support the district court's findings did not support or warrant a dismissal with prejudice or a denial of plaintiff's dismissal without prejudice. So I ask the court reverse the district court's decision and remand for further instruction.
Thank you very much for your argument. Any other questions from the panel at all? Okay, with that, we will conclude this matter. We'll take it under advisement and issue an opinion as quickly as possible. Okay, thank you very much for your argument today.